Hi everyone, I'm attorney Poonam Minhas. I practice U.S. immigration law all over the United States. Today, I wanted to talk about why some parents of U.S. citizens may adjust their status to a green card in the United States and others may not. Before I jump into the topic, make sure to hit that subscribe button and the notification icon to stay updated on anything I post on U.S. immigration law. And if you like today's topic, then please do hit that like button as well. Common situations I run into are U.S. citizens who want to help their parents obtain a green card. And some of them think, okay, now I'm 21, I'm also a U.S. citizen, I can just apply for my parents. Simple, everything is good, let's do it. Hold up. It's not that simple. It really depends on the parent's immigration history and also their entry, if there is an adjustment of status that is being sought to be applied in the United States. And then if the process ends up being consular processing, then that's a totally different process in itself. But you also do need to make sure that you know about your parent's immigration history before applying for any applications. So generally, there are two processes that occur. Adjustment of status, which is done if the beneficiary is physically present in the United States and they're eligible to file for the adjustment of status, which typically ends up them receiving a green card, granted that they don't have any other issues on their plate. And the other process is called consular processing, which is done abroad, where your parent, or I should say the beneficiary, goes through the interview process after dealing with, National Visa Center, and then ultimately in front of an officer at the U.S. consulate at their home country. So that's known as consular processing. Now remember, two different processes. We're also going to discuss subtopics, and we're just going to cover them briefly so it makes sense. One of them is why some parents are able to adjust their status in the United States and why some parents have to go through consular processing abroad and can't get the green card in the United States. And finally, why is it the proper strategy for you to know about your parents' immigration history, and why is it critical to know if there's any issues in front of you before filing those applications? Okay, so let's talk about this again. The adjustment of status allows a beneficiary to adjust their status to a green card in the United States without leaving to go abroad. And typically, the situations that do come up is you want to see if your parent or the beneficiary came into the United States lawfully, or were they inspected, paroled, and that's very, very important. Do they have a certain visa that they entered with and then they overstayed? Could they still qualify for adjustment of status? They may, and they might be able to apply for adjustment of status in order to seek the green card. But where do the issues arise? What if there is fraud or misrepresentation? What if, and I've seen this happen a lot, later on at the citizenship phase, USCIS discovers that maybe your parent had false claim to US citizenship, and then they are blocked from applying for citizenship. Now, I don't want to go into that deeply, but that's one of the issues that do end up coming up. And that could also come up at the adjustment phase before a green card is even issued. And then you have to really look at and see, oh my God, is this going to cause a problem? And then what happens from there? There could also be issues that lead to a criminal matter where the person is not adjustable anymore and they're blocked from getting the green card. And there could be several other things. I mean, if you pay attention to the adjustment of status application, there are security questions. There's so many of them. And a lot of them ask about, whether you've been in the United States before and then you left and then came back again, or have you ever been in deportation proceedings? And there's a lot of security questions on there that the beneficiary has to understand and read carefully to see if any of those apply to them. And then it wouldn't be a no, it would be a yes. And then you're like, wait a second, is it possible for this person to adjust? So those are some issues that might come up. But generally, if those issues do not exist, then the person may be successful under their adjustment of status application, and some things may be forgiven. Now, when a child is a US citizen and 21 years old or older, then that parent that they're filing for becomes an immediate relative. So an immediate relative, you don't have to wait for a visa to become available. It's immediately available. You don't have to wait on any line. But there's two parts to that too. Fine, you're able to file an I-130 petition. You're able to establish the bona fide relationship between you and your parent. But now it's the adjustment part where you really have to be a little careful, because hypothetically, if that adjustment of status gets denied for whatever reason it is, then it's a possibility that your parent may end up in removal proceedings. So you have to be very, very careful there. But that's what generally the adjustment of status phase looks like. Some parents are able to get a green card mailed to them without going in for an interview because the interview is waived. And that typically happens when the officer looks at their paperwork and says, well, I have everything. Okay, I don't need to call this parent in for any questioning. I think we're good. We're going to go ahead and issue the green card. But in many cases, there are scheduled interviews where the officer may ask a lot of questions about the parent's immigration history and other factors as well. So just be conscious of that. And if that does happen to you, then it may be best to consult with an immigration attorney ahead of time to know what you're getting yourself into and whether if you need representation at that interview if one is scheduled. The other process is called consular processing, which is generally done outside of the United States. It's done abroad in the beneficiary's home country. Now, when does that typically happen? Okay, either the beneficiary has never ever been to the United States before, okay, never came on a visa, nothing, and you are a US citizen and you turn 21, you're like, I want to petition for my parent now. And that parent is in their home country waiting for you to do this process. So they would go through consular processing, never been to the United States, so they have no reason to do adjustment of status, right? They're physically in their home country. But what's interesting is you want to make sure that they don't have an immigration history. If they don't have one, then that might be straightforward, but then you also want to make sure you have your finances secure and make sure that the parent does not end up being a public charge and gets screened for that. So that's very important. The other example would be if your parent is already in the United States. Let's just say hypothetically, they cross the border, okay? And they don't have a lawful entry. They were not inspected and paroled in or anything like that. So now it gets a little tricky. Now you have to think about whether they meet any type of exception to try to get the green card in the United States. Is there a different type of relief they could file? Or if the only route is to file the petition through their child who's now 21 and a US citizen, whether the parent can overcome unlawful presence by filing a waiver, or if there's any fraud issues that might end up being a waiver to be filed later, or if they have a deportation order, let's just say, and there needs to be a waiver for that as well. But for those waivers, in order for the parent to even qualify to apply, there has to be a qualifying relative for them, or you have to make sure that they meet the requirements. And there have been many situations where the parent is okay at the I-130 petition part, but then they're like, wait a second, I don't think I can file this waiver. I'm stuck because I do not have a qualifying relative to show extreme hardship to. And then it never even gets to the next phase or even ends up going to consular processing because now they're stuck in a situation where they can't really leave and try their processing abroad. So this is why it's very, very important to consult with an immigration attorney who knows what they're doing and evaluate each case. I can't begin to tell you how many individuals have either successfully gotten their green cards and then later stuck at the citizenship part, where then they were handed a notice to appear to end up in removal proceedings, and now they're fighting to keep their green card, or they end up being in a situation where they're stuck at the adjustment of status phase, which ultimately, if it gets denied, ends up going into removal proceedings sometimes. So that's really, really important. You want to make sure you don't end up in those type of situations. And if you do, then you need to make sure you get the actual help that you need, because dealing with, certain parts of the law, the statute, the reasoning as to why you were denied a certain application benefit, you need to really understand why it happened and how it happened. So that's really, really important, and how you can move on from that. Is it best to file an appeal? Is it best to, refile my application? Oh no, I ended up in removal proceedings. What do I do? Is there any other form of relief that could be filed? So really get the case evaluated to see what could happen. So yeah, that's the consular processing phase of, there's like waivers that get filed in the United States, wait for the approval, and then ultimately you go to the consulate, do your interview, and make sure there's no issues at that point, and then you would be able to come in. And that generally does happen with certain applicants, and that's why they are not able to get the green card in the US, because their process is a little more different. So the reason why I wanted to have this topic to really break down two different parts of what a parent's process looks like if they were to do adjustment of status, and why some parents are able to do that versus some are not. The main reason also was to pretty much say, hey, be a little careful, be a little more proactive, and really know what you're filing, what you're getting yourself into. They are not just applications that get filed. Some of the situations may have serious consequences. So definitely schedule a consultation with an experienced attorney. If you do the full-fledged consultation, share your documents. If you have documents in your possession and they need to be reviewed carefully, do that, because at least you'll know where you stand, and you're going to be the one to make the decision whether you want to move forward with the case or not, and know the pros and cons of doing so or not doing it, and what will happen if something goes south, or if it's straightforward, then you'll be told, okay, you know what? You might not experience any issues, but if something else comes up, this is how you prepare for it. And the other thing that is important is, let's just say one option is not available to you, but there might be other options. You might qualify for other forms of relief. And it's best to know, hey, maybe I can apply for more than one thing, okay? Maybe I can apply for this relief, and they can both run parallel, and then we'll see where the green card comes from. That has happened as well. I know some people are scared and they're like, well, can we file for, for my U visa and then also do a green card case through my child? Could be possible if you qualify for both. It's a possibility. There's certain relief that's also only available before the court, but then you could potentially have relief that's available both in court and with USCIS. And then you just have to figure out whether you can do both, do one, or have a backup plan and see if it's possible for you to do a different type of relief. You're not going to really know until you speak to someone experienced and really lay out your immigration history and talk about what's happening in your life. And sometimes things in your personal life could be a factor in determining, well, you might qualify for this relief, right? So that was the whole purpose of today's topic, to really share and break down what the two different processes are and why it works out for some people to adjust and some people not so much. So if you are a US citizen who turned 21 and you're like, I want to help my parent get a green card, and you're not sure about the US immigration laws and the process, it would be best to schedule a consultation with an experienced immigration attorney and really get an understanding of what your options look like. One extra tip I would like to say, if you don't have the finances, let's just say you have a straightforward case where your parents don't have this crazy immigration history, and you go ahead and you file the paperwork or are ready to file the paperwork, but you don't have the finances because you're a student or something. That doesn't become a straightforward case. It actually becomes an issue because you don't want to go ahead and file something and then USCIS gets it and be like, you know what, how come they don't have an affidavit of support from somebody who could have qualified to, financially support these beneficiaries, okay? And then that could potentially end up in a denial. Some people don't get an opportunity to get issued a request for evidence and get that time frame to respond to the RFE. Some people are not that lucky and they get a straight denial. And then you are risking and putting your parents in a situation, if they overstayed on their visa, that they potentially could end up in removal proceedings. And then that's another headache you don't want to deal with. And the other thing is, you also want to make sure that whatever you're filing with the government, everything's there, okay? And you have all the instructions read. This is if you're doing it pro se, but if you're working with an experienced immigration attorney who knows what they're doing, then you could just work with them and make sure everything's intact. But as far as I know, just make sure that everything is filed up front. You're not just filing bare minimum and risking a denial or risking a RFE where you only have a 30-day deadline. And now you're like rushing and trying to figure out, oh my God, am I going to get these documents in time to respond to this RFE, and then, make sure it gets there before the deadline. So just be conscious of that. Again, if you like today's topic, please hit the like button. Share this with your friends and family, because you never know who it might help. And if you haven't subscribed, hit that subscribe button, hit the bell icon to stay updated on anything I post on U.S. immigration law. Hey, use the comment section below for general questions if you have. And if you have something personal to your case or your matter or questions related to your parents' case, do not use the comment section. Pick up the phone or email me and schedule a consultation. I do initial consultations for free, so take advantage of that if you may. All right, well, thank you so much for watching, and I will be back with more informational videos.